Hey guys, this is Eric Rodebois. We're going to be doing a 5-minute video here, EPGD Attorneys at Law. So I just did a 1-minute video talking about how some things are so important that they have to be in writing. And the law that they teach us in school is called the Statute of Frauds. And what it says is that some things are so important that you have to write them down, that they can't be an oral promise. So here's a fact pattern from true life, okay? Next door neighbor of this lovely couple, lovely family is a single old man, okay? He's an old man, he's not married, he doesn't have any kids. In fact, we don't think he has any relatives. We think he just was the nice old man next door. And they were friendly and they had a nice little pleasant relationship with their neighbors. And one day the old man says, you know guys, I don't have any next of kin, so when I pass away, I want you guys to have my house. And the next door neighbors were like, wow, that's so nice. Thank you so much. That's so great. And that's all they did. And they went about their business and they went about their lives and they, brought it up every once in a while and they'd invite him over for a beer or maybe he'd come over for the barbecue and he'd say, yeah, remember when I pass away, the house is going to you guys. And they'd say, oh, thanks. That's so nice. But the problem is they never wrote it down. Okay, they never went to a lawyer. They never even went to Office Depot and bought those forms that you can buy. Which, by the way, I don't recommend you do that, but trust me, that's much better than nothing. Because what they have now is nothing. And so what ends up happening, it's very sad, is that the gentleman passes away, and the way he passes away is they just stop seeing him around. And they start to notice like the weeds in the yard piling up. And finally they go over and knock on his door and he doesn't answer. And they start looking through the windows and they actually see his body through the window. So they call the paramedics. Paramedics come, they force their way into the property. And what they'd said is that they found him mummified. He had been there decomposing for so long that his body was beginning to mummify itself. I don't even know what that means. I didn't go to medical school. Doesn't sound good. And so, unfortunately, they take him away, and the next door neighbors will say, well, what's next? And the paramedics say, well, we don't know. Talk to a lawyer. And they call me, and I said, okay, well, was there a deed? No. I go and I check the property records. It was still in the decedent's name, the old man who passed away. Was there a will? Well, honestly, we don't know. And, we kind of feel weird. Like, should we break into this guy's house and start looking through his papers to see if he had anything? And they're like, well, we had a key, we were really friendly. So they go in and they look through and they can't find anything. And they're wondering if there's next of kin. And so they're at a loss. They're like, what do we do? Right? What do we do next? And the body, by the way, is still in the morgue because nobody's claimed it. Very sad. And then what's really frustrating is the family next door says, well, he said the house was going to go to us, so what do we do? And so we're stuck with this really weird situation, right? Because they're not family. So they're not listed in a will, they're not named as personal representatives or as beneficiaries, and yet they might be considered interested parties. The law in Florida is that an interested party may petition the court, and the interested party is not really well defined. And so maybe the beneficiaries of an oral intent to leave property to somebody makes them at least interested parties enough to where they could file a petition with the court and then ask a judge to get involved. Because that's the path we're on, right? Because the probate court handles transferring property from decedents to next of kin. Now, a good estate planner will tell you that if we do our job right and we use trusts and deeds and wills, we can actually avoid probate, which is part of the goal of estate planning. But sometimes you have to do probate, right? Sometimes the person passes away without a will or with only a will without a trust. And so we're kind of at a loss. And the lady's like, well, what do I do? And the answer is, I've been practicing law for 15 years and I don't know the answer. In 15 years, I've talked to tens of thousands of people and no one has ever presented this fact pattern. My next door neighbor made a promise to give me his house but died with no next of kin and no will. I'm at a loss. So we'll see how we can help the lady. We're going to do our very best. But guys, the moral of the story, the word to the wise is if your neighbor says, I'm going to leave you your house, go talk to a lawyer. If somebody says they're going to leave something in their will, go talk to a lawyer. If these things are important, make sure that they're written down correctly. Because otherwise, guess what? If you die with no next of kin, all your property goes to the state of Florida. So that's who's going to be the beneficiary. And then the next door neighbors, if they want this house, they might try to buy it at a tax auction. Not really sure. So guys, once again, Eric Grotebaugh, thanks for checking in.